Nortel Companies and Lehman Companies.
These appeals raise questions of some significance arising out of the interrelationship of the statutory schemes relating to the protection of employees' pensions and to corporate insolvency. In order to protect employees from the adverse consequences of an underfunded occupational pension scheme, the Pensions Act 2004 introduced a Financial Support Direction (FSD) regime. This enables the pensions regulator in specified circumstances to undertake two actions. First, to impose by the issue of an FSD to some or all of the other group companies, known as targets, an obligation to provide reasonable financial support to the underfunded scheme of the service company or insufficiently resourced company in the group. Secondly, to deal with non-compliance with that obligation by imposing, through a contribution notice, a specific monetary liability payable by a target to the trustees. Many UK registered members of the Lehman Group of Companies and of the Nortel Group of Companies have gone into insolvent administration. One of those Lehman Group companies entered into service contracts with and ran a pension scheme for the benefit of employees who worked for other group members. The Nortel Group included a company which had a pension scheme and which was insufficiently resourced to fund that scheme. The pension scheme in each case was a final salary scheme, which appears to be, and to have been for some time, in substantial deficit. The pensions regulator subsequently initiated machinery under the 2004 Act to require certain other group companies, called the target companies, to provide financial support for the scheme in question. The machinery has been held up so that it can be decided how the administrators of the target company should treat that company's potential liability under the FSD regime, in due course what will become a liability under a contribution notice, in a case where the FSD is not served until after the company has gone into administration. There are three options as regards where the liability would rank in such circumstances. The first is that the liability is an expense of the target's administration, which ranks ahead of the unsecured creditors and may therefore well be paid in full. The second option is that the liability ranks pari passu, in other words, equally, with the other unsecured creditors. The third option is that the liability would rank behind the other unsecured creditors and would therefore almost certainly be worthless. Mr. Justice Briggs in the Court of Appeal concluded that the second option, pari passu, was not open to them and preferred the first option, that is, preferential treatment, to the third option, that is, no treatment at all, holding that the liability was an expense of the target's administrations and therefore ranked ahead of the unsecured creditors. The Supreme Court unanimously allows the appeals and holds the second option to be correct. The liability ranks equally with the other unsecured creditors. The Court therefore declares that a target's liability under the FSD regime, arising pursuant to an FSD issued after the company has gone into administration, ranks as a provable debt of the company and does not rank as an expense of the administration. I give the main judgment of the Court, with which Lord Mance, Lord Clark and Lord Toulson agree. Lord Sumption gives a short concurring judgment, with which Lord Mance and Lord Clark agree. It's common ground that if a contribution notice had been served in respect of a target before an insolvent event, it would give rise to a provable debt. The courts below considered that if a contribution notice were issued after an insolvent event, it would also give rise to a provable debt, provided it was based on an FSD issued before the insolvent event. It appears somewhat arbitrary that the characterization and treatment of the liability under the FSD regime should turn on when the FSD or contribution notice appears to have been issued, if it is based on a state of affairs which existed before the insolvent event. In these appeals, the liability which was imposed on the target companies on the issuing of the FSD can be said to be a liability which arose by reason of an obligation incurred before the insolvent event. This is for the reason that, before the target companies went into administration, each company took or was subjected to a step or a combination of steps which had some legal effect and resulted in it being vulnerable to the specific liability in question, such that there would be a real prospect of the liability being incurred. That conclusion is also consistent with the whole nature of the FSD regime. Mr. Justice Briggs and the Court of Appeal felt constrained by a consistent line of authority from reaching the conclusion which we have reached, although it appears that they would have so held if they had felt able to do so. The earlier authorities they relied on should be overruled. The judgments are very short in their reasoning, they're inconsistent with another line of authority, and they were decided at a time when the legislature and the courts were less anxious than currently for an insolvency to clear all the liabilities of a bankrupt, and they were all concerned with individual, not corporate, insolvencies. My judgment deals with two further points which strictly only arise if, contrary to our conclusion, a contribution notice would not give rise to a provable debt. First, on that hypothesis, the courts below were wrong to have concluded that a contribution notice would have given rise to a liability which was to be treated as an expense of the administration. Secondly, on that basis, it would not have been open to a court to change the statutory priorities to enable the liability to pay pursuant to a contribution notice to be, in effect, promoted to a more preferential status.